Welcome to James Madison's Montpelier. I'm Ryan Nobles from NBC 12 in Richmond, and we're continuing our conversation on the Bill of Rights. Joined by Police Chief Tim Longo from Charlottesville, who's also an attorney, Hank Chambers, who's a law professor at the University of Richmond, and Peter Irons, who's a widely published author and the political science professor emeritus at UC San Diego. And let's start with you, Chief. We're going to talk now about the Sixth Amendment and an overview on a speedy and public trial, as well as an impartial jury. And I think one of the things people always wonder is, how do you define a speedy trial? And how did the Founding Fathers define a speedy trial?
That's a very good question. Oftentimes, speedy trial provisions or speedy trial rights are established in state law, and it may not be unusual to say, for example, by the time the person is arrested and charged with a crime, they'd be brought to trial within 180 days or otherwise waive their speedy trial rights. And the importance of that is we don't want to lock someone up for 2 or 3 or 4 years and haven't given them the opportunity to be heard, to confront their accusers, to hear the nature of the charges that have been placed against them. And it's again, much like we talked about with respect to the Fifth Amendment, the Sixth Amendment is about fundamental fairness in the criminal justice system. Mm-hmm. It's about being represented by an attorney. It's about being afforded a speedy and fair trial. It's about having a right to be judged by a jury of your peers. It's about confronting your accuser or witnesses that might be called against you. Mm-hmm. All those things are about fundamental fairness.
Mm-hmm. And Peter, why did the Founding Fathers in particular address specifically the issue of how long it takes to bring someone to trial?
Well, this is because, once again, the colonial experience, when the colonies were ruled by the British, and there were examples, numerous examples, mm-hmm. of people being held indefinitely without trial, and basically just locked up and with no opportunity to get into court to defend themselves. This is one of the reasons the Constitution also contains a provision for habeas corpus, to get yourself before a judge. But the provisions that Chief was talking about of a speedy trial, right to counsel, impartial jury, as a practical matter, these are all great things in theory. As a practical matter, enforcing them. For example, it was not until recently that the Supreme Court ruled that prosecutors, for example, could not strike people from jury duty because of their race or their gender. And this was a very common practice, particularly in the southern states. And that made it unfair when you have, for example, an African-American defendant who's being tried by an all-white jury. We saw during the 1960s the result of this, when police officers and other vigilantes were tried, for example, in Philadelphia, Mississippi, for the murder of civil rights workers, and were immediately acquitted by all-white juries. They're not going to put the deputy sheriff in prison. And it wasn't until federal prosecution came in for that. So, as a practical matter, you try your very best to, and honorable prosecutors and judges will try their very best to make sure that there's no bias in the system. One of the most serious problems that many defendants confront, particularly in capital cases, is ineffective assistance of counsel. Lawyers are appointed by a judge who may have no particular training or experience in trying these kinds of serious cases, and they screw up. Mm-hmm. And sometimes innocent defendants get convicted, and it takes years and years mm-hmm. to correct those mistakes.
Hank, one end of it is the speedy trial, the other end of it is a public trial. And obviously a public trial in the times and colonial times is much different than what a public trial may be today. Are we still wrestling with the definition of what a public trial is?
Not really, because they're all open. The only piece that you really need to wrestle with is the notion of how open do they need to be.
Right. As a member of the press, I would say cameras in every courtroom, streamed on the internet.
And that is the piece of the puzzle that's out there, is should I be able to see the trial in the way that I want to, court TV everywhere, or is the point simply to make sure that someone can see the trial and report on it so that we know that there aren't a whole lot of shenanigans going on? That's really the question. But it is to say that having trials out in the open is very important. You can imagine the problems of having trials in secret and then justice, in theory, or punishment being meted out as a result.
Chief, you saw this firsthand, the struggle between access to a high-profile trial, and the two edges of that sword where it can become somewhat of a romper room in the Hughley case. You obviously didn't make the decision over whether or not cameras were allowed in the courtroom, but you had to kind of administer the access that the public had. How difficult can that be when there is such a big, high-profile trial?
Well, it can be hugely difficult. I'm an advocate of transparency in every respect, and certainly within our criminal justice system, I'm a strong advocate of that. However, the judge has a responsibility to control the courtroom, to be able to make sure that what takes place in that courtroom is done efficiently and fairly and without disruption or distraction. You can imagine with the number of media that was present at a trial that we just had recently here in Charlottesville, if every one of those persons would have had the ability to be able to bring equipment into a courtroom, how disruptive that could have been to those judicial proceedings. So I think the judge in that case made a wise decision by allowing representatives from every media outlet in that room, by controlling the electronic equipment that they brought into the room, by setting up a satellite facility so that they could view the proceedings from a remote location. I think that made perfect sense in that kind of situation, and I think a judge needs to be able to retain that right.
Gentlemen, thank you.
Thank you.
Thank you.